Good morning. My name is Alan Campbell, and it's my privilege to represent Callum Miller in this appeal challenging his conviction for first-degree murder. I've raised 4 issues in my brief, and I hope to be able to touch on at least 2 or 3 of them this morning. The first issue that I would like to address is the defendant's argument that he is entitled to a new trial due to the lack of instruction on the lesser-included charge of assault and battery. The law is that where there's a rational basis in the evidence for the jury to acquit of the greater charge.
Isn't the assault and battery the hitting with the hand?
Yes, that is, Your Honor.
And isn't that really very separate from the murder?
I don't believe it is, Your Honor. The indictment for murder is that he did assault and beat Edward White, and then by that assaulting and beating, he did kill him.
But it's assault and beating with a hammer. I mean,
Actually, the indictment does not say assault and beat with a hammer.
No, I know, but the facts are that, right?
The facts are that he was beaten by Mr. Miller. The start of that beating was with the hand. Moments later, he was hit with a hammer. There were some of the wounds that the medical examiner described included wounds that could have conceivably been caused by the fist, so that they are part and parcel. And that the law also is that assault and battery is a lesser included offense of murder. It's a general law. It's I don't know what the percentage is, but it's a very small percentage of murders that don't involve a gun, a hammer, or a knife.
Now, in this case, was there any request for an instruction of involuntary manslaughter?
There was a request for a manslaughter based on provocation.
For voluntary manslaughter?
For voluntary manslaughter.
But no involuntary manslaughter was sought?
There was no request for involuntary manslaughter, no.
Okay, and you're saying it's okay that there's no involuntary manslaughter instruction because you're focused only on assault and battery?
I believe that on the law of for that manslaughter, that since the fist did not cause the death, there was no basis in the evidence for that instruction.
For involuntary manslaughter?
I believe that when the conduct, for that law, that when the conduct could only result in, I think it's the substantial risk, substantially likelihood of death, that instruction is not called for. If I've in error, and that's certainly
there was no instruction asked for, so you're basically saying it created a substantial risk of a miscarriage of justice for the judge on his own not to give an assault and battery instruction here that was not sought by the defense?
Yes, on the facts of this case, I do believe that it was a substantial likelihood of a risk of miscarriage of justice.
And what would the jury have had to find in order to get to that lesser included?
They would have had to have credited the evidence of the defendant's mental impairment and intoxication, which was sufficient to negate malice. So the jurors could have credited that evidence, found that he did not act with malice, and therefore it was not murder, but that he had struck him with his fist, and therefore there was a basis in the evidence for finding assault and battery.
And how persuasive is that when the jury had the option of finding him guilty of second-degree murder, but found him guilty of first-degree murder?
Well, I looked to Gilliard, which is a murder case where the jury was given the options of first-degree, second-degree, and manslaughter. They came back with the second-degree, and the appeals court later affirmed the granting of a motion for new trial based on the higher standard of ineffective assistance of counsel for not requesting an instruction on assault and battery. And that was even though trial counsel had expressly pursued an all-or-nothing strategy at trial and had not requested the assault and battery instruction. Remember, in this case, trial counsel was not going for an all-or-nothing. They had hoped to have a lesser-included charge.
But was there any dispute in this case that the defendant had struck the victim with a hammer?
I don't believe there was, Your Honor, no.
And there was also no dispute that the cause of death was the wounds inflicted by the use of the hammer.
I would agree. The cause of death was not an issue at trial.
So why would an assault and battery have been a proper lesser-included instruction?
Because if the jury credited, there is no dispute that he beat the victim both with a hammer and without a hammer.
But the case of Gilead, which you cite to support you, I've read it, and Gilead, in that case, there was evidence that the defendant participating in a joint venture only to beat the victim with her fist, and there was no evidence that here there was just that the defendant's intent was only to hit this victim. So I don't think that Gilead supports what you're saying.
I'm not certain what other lesser include. I'm sorry, let me just think for a
Was
second.
voluntary manslaughter given?
It was not in this case.
Sought but not given?
Correct.
And what was the claimed provocation?
The claimed provocation was some reference to belief by the defendant's expert in describing what may have caused the defendant to do this, the added provocation of, I forget exactly what it was, but as that had
Take
not
it, it was
actually...
Is the
It was the-
flashback to his sexual
the
abuse when
advance.
he was under the
Sexual
influence of
advance.
alcohol?
Wouldn't it be the sexual advance that would be the provocation?
That certainly was one of his arguments, but there's case law that cited by the Commonwealth at the trial that indicates that that's not enough to get you there. There was an additional avenue that he attempted to get it in through, but since that evidence had only come in as the basis for the expert's opinion and hadn't come in at all, there was no basis for the instruction. And I must point out that trial counsel opened the case saying what the defendant did was horrible, what he did was criminal, and he wants to take responsibility for it. And then he finished his closing argument by again saying what he did was horrible, what he did was criminal, and he wants to take responsibility for
So,
it.
given that, what possible rational value, purpose would there be to have an assault and battery? I mean, your argument that somehow the jury could have found, lack of malice and therefore settled on assault and battery when it's admitted that he killed the victim?
Yes, Your Honor, not all killings are murder.
But how could it be just assault and battery?
It could be just assault and battery because he hit the victim with his fist. That is an assault and battery. He also hit him with the hammer, but whereas the jury could have rationally not found malice, they wouldn't have found murder.
But is there any question that the basis for the indictment wasn't the hitting with the hand? The basis for the indictment was the striking with the hammer.
The indictment is just the standard indictment. He did assault and beat Edward White, and by the assault and beating did kill him. It doesn't mention a hammer.
But what about the grand jury minutes? I mean, doesn't everything in this case point to the fact that the whole theory of this murder was that the defendant was struck by a hammer, or the victim was struck by a hammer, and that caused death?
The hammer certainly was the cause of death. However, it is the defendant's position that the striking with the fist was part and parcel to the incident, to the beating.
But that was a separate crime. It was an unrelated crime for which he had not been charged. There was no evidence that the striking with the fist caused the death. Isn't that right? It was an unrelated crime.
I believe there actually was some evidence that the victim may have been injured by the striking of the fist, so in that sense it could have contributed to it, but it wasn't a method of death.
But if you peel away, if you go all the way down the ladder from murder, you come down to manslaughter, you come down to assault and battery by means of a dangerous weapon, the striking with the hammer. You can't peel away the hammer and then say that there was an assault and battery, because that was a different assault and battery. It was not the assault and battery which was connected to the death.
Well, it's the defendant's position that whereas it was part of
Well, it may have been
beating.
part of the whole transaction, but he was never charged with the separate assault and battery. It was not the assault and battery that was part and parcel of the use of a hammer that resulted in the death.
Well, with all due respect, the defendant is never charged with a lesser included offense. They're charged with a greater offense, and the lesser charge is part of that.
Okay.
Do you want to address your arguments about the closing argument of the prosecutor?
Yes, please. Yes, Your Honor. In this case, the defendant's position that the prosecutor made three errors in his closing argument. One of them was as he closed his argument, he indicated to the jurors, not the most clear language, but certainly implying that their duty was to find the defendant responsible for the crime. I believe he says words to, it's a hard job. You need to hold the defendant responsible. Sorry. The defendant's responsible for what he did. It's a hard job, but you're sworn to do it, thereby implying that it was the jury's job to find him guilty. Another error in the argument is when the prosecutor discussed the defendant's expert, he indicated on a couple of occasions language that implied that you did not need to consider the evidence of either experts. On one, specifically volume 7, page 57, now tit for tat, put them aside and do your job, look at the facts. That's improper.
Why is it, well, was it, it certainly wasn't improper to say that you should not find the defense witness to be credible.
That certainly would be a proper argument. Consider the experts. The Commonwealth's position is that the defendant's expert is not credible, therefore believe our expert.
And isn't that the gist of the closing? I mean, I read it. He was speaking about the inflation of his credentials and various other things with regard to it, which he thought the jury would find that that witness was not a credible witness. I mean, mustn't we view the closing in its entirety as opposed to taking one or two lines and taking that as the whole of the argument?
The prosecutor certainly did go through, to a certain extent, indicating why the jurors should not credit the defense expert. But however, on a couple of occasions, the prosecutor did tell the jury, just don't look at the experts, just look at the facts. If you don't want to listen to the defense expert, then you know what you can do? Don't listen to our expert either, just look at the facts. And whereas really the only facts that were in dispute in this case was whether or not the defendant acted with malice, that's an improper argument. The jury should have been looking very closely at both experts. The Commonwealth mentions in their brief something to the effect of that much of the trial was academic. And in fact, much of this trial was academic. There was no dispute that the defendant had lived with the victim, that the defendant killed the victim, that the defendant went to New York and came back, that he was arrested, that he gave a statement. None of that was in dispute. What was in dispute was the defendant's intent at the time that he beat Mr. White, his knowledge of the circumstances, his capacity to act with malice, his capacity to premeditate, and his capacity to be able to act with extreme atrocity or cruelty. And the Commonwealth's closing argument shifted the jury's attention away from that crucial issue to just looking at the facts without considering the experts.
Now, what perplexes me in this case is this is a case not claiming lack of responsibility, but claiming diminished capacity, correct?
Correct.
And diminished capacity generally leads to a lesser crime than the crime alleged, correct?
Correct.
But here, the claim was there was no malice, and he was charged with first and second degree murder, both of which require malice. So if the jury were to find no diminished capacity, they'd have to acquit.
If they found no diminished,
I think
or
it's-
no
if-
diminished capacity, okay.
I mean, if the jury had found diminished capacity, or the jury, more precisely, if the jury had found the Commonwealth had failed to prove beyond a reasonable doubt that the diminished capacity defense was not sufficient and there indeed was not malice. Well, I'm sorry. If the jury had failed to find malice, they'd have no choice but to acquit. So you have a diminished capacity defense, which is essentially a lack of responsibility defense in the context of this case.
In the context of this case, had the jurors credited the diminished capacity defense, then acquittal would have been the result, which ties in with the argument of...
But it was tried both as, the verdict was extreme, you just said this, right? The extreme atrocity or cruelty and not deliberate premeditation?
Right.
Correct.
But it was tried for both, right?
Yes. It was tried for both.
So
and
at
both
least
instructions were given.
at the time of trial, there would be a reason diminished capacity could have gotten you to a second.
Could have got what?
Certainly, if the
Could have
jurors had
gotten to a
found,
second-degree murder as opposed to a first-degree murder.
certainly the jurors could have credited the evidence of mental impairment and intoxication and found that it negated premeditation and extreme atrocity, but found that it was malice. So it could have resulted in a second-degree murder. Yes.
I'd like to turn your attention, if I could, to the instruction that you are claiming was error, the instruction about malice from the inference from use of a dangerous weapon. I looked at the judge's instructions, and it's the way he structured them, which I think is the way we've told trial judges to structure them, in effect, was that after all the instructions on first-degree and second-degree murder, then as a general instruction, the judge gave the challenged instruction on the inference of malice and the instruction on intoxication and mental impairment and what that evidence could be used for. So it seems to me it wasn't in connection with the three prongs of malice that he gave the instruction. He didn't add another prong. He just referred back to everything when he gave that instruction, which is, in effect, what this court has told the trial judges to do.
Well, I believe even though it didn't follow in the instruction on malice, I believe that the instruction did add a fourth prong to malice. The judge, in going through malice, says malice is this, may be proved in these ways, and describes it, and then later on says you may find malice if you find that the defendant intentionally used a dangerous weapon on another person. However, malice is it's a complex term. Jurors, when they hear malice, I don't believe they think, okay, malice, there are three different ways that malice can be proved. The jurors were instructed that malice was an element. So later telling the jurors, you may find malice from the intentional use of a dangerous weapon, if the jurors are presumed to follow the instructions, the jurors have been instructed, okay, malice is one of the elements. Oh, and I can find malice from the intentional use of a dangerous weapon. It certainly wouldn't be unreasonable for the jurors to have thought that I can find malice from the intentional use of a dangerous weapon. The instruction doesn't say you may infer malice under any of the three prongs that I previously defined for you. It says you may find malice. Again, malice is the element. And I believe the way the instructions came down, malice also precluded the jurors from considering malice, from considering the evidence of mental impairment, intoxication on the element of malice. Because
But he said that they could consider it on any time that his state of mind
well,
was
what the
in
judge says
question.
is, whenever the Commonwealth must prove intention or knowledge, you may consider it. And then he repeats it. And then he says, these are the three things and then he says, malice include, or more particularly, you may consider it on, and then he goes through premeditation, extreme atrocity, and the three prongs of malice. Those are the only three elements in the case that required the Commonwealth to prove knowledge or intent. The use of a dangerous weapon wasn't an element of the crime. The Commonwealth never had to prove as an element that the defendant intentionally used a dangerous weapon on another person.
But to find malice from it, they would. I mean, that's part of the definition. Because you may infer malice or you may find malice from the intentional use of a dangerous weapon. So they would have to find intent.
Well, as I said, when the court describes the elements and says what the elements are, intentional use of a dangerous weapon was not one of them.
Yes, I know, but the instruction that's in your brief, the Commonwealth's brief, says whenever it has to be proved that the defendant intended to do something, you may take into account whatever.
No, not you may, you should.
You should take into
You
account.
should take into account.
Right.
Well, however, whenever you may, whenever you need to do it, that language was then curtailed or limited by then following it with the three examples of when you could use it.
It seems to me that you're confusing elements with evidence. The judge never said that the use of a dangerous weapon is an element of malice. He said you may consider it as evidence of malice. It's really just evidence. It's not
The
a
judge
substitute for an element.
I would disagree. The judge didn't instruct that you may consider that as evidence of malice. The judge says you may infer malice from the use
Isn't that
of.
the same thing?
I don't believe it is, Your Honor. I believe the difference may be subtle, but by saying you may infer evidence, that goes straight to the element. You may infer this element.
But if what you're saying is true, the judge would have instructed the use of a dangerous weapon in the course of a homicide is malice, by definition.
I believe actually that is essentially what the result is in this case.
At
is
least
that-
according to Mr. Steinfeld, and looking at the, I mean, I haven't looked at the jury instructions, but one is on page 100 and one is on page 101. As soon as he instructs about the intentional use of a dangerous weapon, he immediately then re-instructs, as I understand, and Mr. Steinfeld can correct me, whenever the Commonwealth must prove the defendant's intention to do something.
Right, but then he immediately follows that whenever instruction with a list of 3 areas where they may consider the evidence of mental impairment, intoxication, and in that list he does not include the intentional
Okay.
use of a dangerous weapon.
It's the more particularly that you're concerned about.
Exactly.
Thank you, Mr. Campbell. Good morning, Mr. Steinfeld.
Good morning. May it please the Court, Kenneth Steinfeld for the Commonwealth. I'd like to address briefly the issues raised in the defendant's brief in the order in which he raised them.
But let me ask you about the issue of manslaughter. Was a manslaughter instruction given in this case?
No, because the Court held that there was not sufficient evidence of provocation. The proffered bases for the provocation were the sexual advance, plus also some comments that the victim had made about the defendant's girlfriend's son. He had said something about he was going to try to make the boy gay, and that had upset the defendant. The judge held there are cases that state that a homosexual overture is not sufficient provocation as a matter of law, and of course mere words, the words "I'm going to make the boy gay," were also not sufficient provocation. So the judge correctly held that the evidence did not support an instruction on manslaughter based on provocation.
Was there evidence upon which a jury could have concluded that the defendant attacked the victim with a hammer to prevent him from making a phone call, and he did not intend to kill him? Was there evidence that...
Sure, the judge,
So why
based
wouldn't...
on the defendant's statement, the jury could have been found. The defendant's statement was admitted, of course, substantively, and in there he does talk about that he attacked him right after he was trying to make a phone call to alert police or to do something. So the jury could have found, based on his statement, that his intent was merely to prevent him. However, they were not necessarily, they didn't necessarily have to find that given the severity of the succeeding attack.
Well, but they could, if they could have so found, isn't that enough to entitle him to a manslaughter instruction?
Well, the issue was not raised below or discussed. I think
For purposes of 33E review.
to prevent him from making the telephone call, I don't think so, Your Honor. I think that in the context of the attack itself, it would have been unreasonable, if not impossible, for a jury to believe that that sort of force could have been asserted merely to prevent the making of a telephone call.
Well, if you wanted to get the manslaughter, wouldn't it have to be that the victim's effort to make the telephone call was sufficient provocation? Is that, don't you have to, I mean,
Well,
I'm trying to figure out how you would
well,
get
but as
to
a matter of law, that's not sufficient, I would say. The
I'm
mere
not
fact
disagreeing with that, but it seems to me you've got to cast it in terms of the provocation in that.
Well, it was not so cast below. It was based solely on the sexual advance.
But forget provocation for a minute.
Yes.
Is an assault and battery that results in death can be a manslaughter.
Involuntary.
Yes.
Is there any evidence upon which the jury could have concluded that the defendant really was only intending to assault and beat, albeit by means of a dangerous weapon, the victim?
No, I think that it would be unreasonable for them to have interpreted the evidence that way. Because of the number of blows, the severity, the weapon used, he knocked him down to the floor, he punched him, he looked around for a weapon, for a more serious weapon than his hand, and that shows a consciousness that he has not lost control. He's actually looking around for a better weapon, and he sees his tool belt right there, and he grabs the hammer out of it. So I think that it would be an unrealistic and implausible view of the evidence that it was a manslaughter. I think this case...
Sorry, Mr. Steinfeld, I think this is similar to what Justice Gantz was asking. Assuming that the jury had, in the circumstances of this case, assuming that the jury had concluded that there was credible evidence of mental impairment and or intoxication, such as to diminish his capacity to intend to do whatever it was, what is the jury, given these instructions, required to do?
Find him not guilty on all counts, because both of the charges, first-degree and second-degree murder, both required malice. First-degree, of course, the deliberate premeditation requires just the specific intent to kill. The extreme atrocity or cruelty are the three prongs, and the second degree, you have the three prongs. If, in fact, the jury credited Dr. Rosmarin's testimony that the combination, the inseparable combination of intoxication and post-traumatic stress disorder symptoms deprived him of that ability, they were instructed, and they had a copy of the instructions with them in the jury room that Judge Lowy provided to them. They were told, and the structure of the instructions was such that they would have had to find the defendant not guilty. That was the entire defense here, and that's part of why I think that a lesser-included instruction of assault and battery would have made no sense, because the defendant would have been saying to the jury, my guy had the intent sufficient to commit assault and battery. He had the general intent to do the act, but at the same time did not form the specific intent to do malice. I think that's a very, very subtle distinction for a defense lawyer to ask a jury to make, and it would have undermined his entire defense that he snapped, that he lost control, that he did not know what he was doing, he did not have any power to stop doing what he was doing.
But what about the lesser-included offense of assault and battery by means of a dangerous weapon? It requires only a general intent. It doesn't require a specific intent. It's entirely consistent with diminished capacity, isn't it?
Well, it is, but it was not asked for, and I think, and therefore the question is whether there's a substantial likelihood of a miscarriage of justice. And the number of blows, the difference, the same argument, I think that would require him to have the general intent. That also would have undermined his overall defense that he snapped. That was the defense. I snapped. I had no control. So I couldn't have had the control or the intent, the general intent to strike him, nor could I have had the general intent to use a weapon on him because I didn't know what I was doing. As he told Dr. Rosmarin, he didn't have any memories of the attack. He followed him. He chased him with the intent to apologize. They fell on the floor, and the next thing he knew, he was kneeling over him, and there was blood and guts everywhere. So,
Mr. Seinfeld, if we adopted the defendant's theory here, would that apply to many other cases as well, then, of the defendant's theory of lesser included?
well, yes, I think it would. I think it would permit
and there'd have to be a lesser included given in almost every murder case.
Yes, and what has not been discussed is the precedent of this court, Myers and Curry, which I think clearly barred the instruction, notwithstanding all of these
I'm sorry,
good
barred the
arguments
instruction as to?
Lesser
I'm sorry,
included.
the lesser included
A and B with
instruction of
dangerous
assault and
weapon.
battery.
Yeah, with a
Which-
dangerous weapon.
Right, I think that also would be included, because that case says that you're only entitled to a lesser included instruction of that nature when there is reasonable doubt that you caused the deaths of the person. All the cases that have permitted lesser included instructions of assault and battery or ABDW in a murder case have involved joint ventures in which there has been more than one defendant. And the evidence was ambiguous, or the evidence was susceptible to multiple interpretations, one of which was that this defendant did not commit the act that caused the defendant's death. Those are the only circumstances in which a defendant is entitled to a lesser included instruction of assault and battery. Here, he was the only actor perpetrating acts on the victim. The injuries were all caused at the same time, and the Curry case talks about that. There was both injury not causing death and also injury causing death, but because there was no dispute that it was the defendant who caused it, the defendant was not entitled to a lesser included. And I think Myers and Curry bar the instruction here, though in fact technically the court held in Myers that assault and battery is in fact a lesser included instruction. I'm sorry, a lesser included offense of murder.
I'm going to put aside the A and B as a lesser included. I'm actually more concerned with the involuntary manslaughter by battery, because you have a diminished capacity defense, saying that because of his intoxication combined with the PTSD, he couldn't have formed the intent either to kill or to,
Right.
or to cause grievous bodily harm, or the third prong. And generally, if that prevails, you get a lesser sentence, a lesser included of involuntary manslaughter battery. The jury didn't have that option here.
No.
And how can you have a diminished capacity defense without the jury having a lesser included option if they were to believe that the defense had merit?
Well, I am not a defense lawyer, obviously. He did not, I don't know why he did not request it. Perhaps the evidence would have supported it, but I really do think there was an all-or-nothing aspect to this. The jury, this was a fairly pathetic man and a fairly pathetic case, and there were sympathetic elements both to the victim and to the defendant. And perhaps the record does not state, because there was no motion for new trial, where we have the tactics of the defense counsel at issue. Perhaps he believed there's no way they're going to convict this man based on this crime of the very serious offenses of first or second-degree murder. I'd rather go for an acquittal.
So you're
than the
suggesting this
involuntary
was a
manslaughter.
Woodward-type case?
Pardon me?
You're suggesting this was a Woodward-type case?
Yes,
Woodward
exactly.
made plain that you can't do that.
Well,
You cannot do that.
well, if you don't ask for the instruction, though, then the question is whether there's a substantial likelihood of a miscarriage of justice.
The question is, if you don't ask the instruction, and if the judge perceives, as you suggest, the judge, that everybody saw this pathetic man with a
Right.
pathetic case, isn't the judge required to give the involuntary manslaughter instruction in any event under Woodward?
If he saw a basis for it.
If he
Yes,
saw a basis.
I don't think he did see a basis for it. The defendant didn't ask him to.
No, but if the entire
ask him to
defense, it's Justice Gantz's point, if the entire defense is diminished capacity, and if they gave credence to that, which I assume is what is implied in the pathetic man with a pathetic case, and the only alternative you're giving the jury is to acquit, when a terrible deed has been done, I mean, that seems to me to be a not even a risky strategy. A strategy that makes no sense, a tactic that makes no sense. It doesn't make any sense at all.
Well, but here you had extremely experienced defense counsel and who vigorously defended and tried this case to the best of his ability. And I think that given the evidence, the jury either believed the experts or they did not. This really was a battle of the experts. But more
Then
so
why did the prosecutor say throw out both the
he
experts?
said, if you throw Dr. Rosmarin's testimony in the trash can, do that to Dr. Rogers as well. He was merely echoing the defendant's own argument that they reached, that they made the same findings, but they reached separate conclusions.
Now,
Can
I'm sorry, go ahead.
No, you go ahead.
Going to the closing.
Yes.
I know that you concede that the last line was error, but you claim it to be...
Well, a tiny error, I think. I think I kind of fudged it a little, and I said to the extent that it could be interpreted as a statement that justice or duty required conviction, it was improper. He didn't exactly do that, but he did imply to some degree that it was their responsibility to find him guilty. But I think every single case that addresses the issue has said that it's not harmful, especially when there's a very long closing. And it's not a do justice, protect the streets, keep him off it. Your job is you will have failed in your duty if you don't convict.
Right.
It certainly was nothing like that.
I actually am focused not on that, but on something else, which was
I'm
not,
sorry,
which was,
Your
which
Honor.
was not. Well, no, I asked you, so it's not your fault. It's not raised in the briefs, but I have read the closing, and one part of it that disturbed me a little bit was a little bit of class, a little bit of reference to class issues through the use of the fact that Dr. Rosemarin had been a graduate of Harvard Law School, and there was a little bit of populism with regard to the
Well,
Which seem, I mean, there was, I know that he inflated his
Right,
credentials. That's fair game. But he did go to Harvard Law School. It should be irrelevant to the jury. That shouldn't be held for him or against him. But I was concerned about sort of the populist tone of the closing.
This is a Harvard Law School graduate speaking.
Naturally. I beg to disagree with Your Honor's characterization of it as populism. It had a proper role in the case. Both experts had Harvard affiliations. Dr. Rosmarin failed to mention that he was a lecturer at Harvard Law,
Harvard Medical School.
Yeah, I'm sorry. Talking about the law school. He stated as part of his credentials at the beginning, telling the jury why they should believe him, I have attended courses at the Harvard Law School. It was Dr. Rosmarin himself who brought it up. Yet, on cross-examination, whenever the prosecutor asked him a legal question, notwithstanding the fact that Judge Lowy had just defined statutory rape and had just defined indecent assault and battery, Dr. Rosmarin said, I can't opine on that. I don't know anything about that. I'm a psychiatrist. Even though he had told the jury, gone out of his way to tell the jury, that he had graduated from, that he had attended classes at the Harvard Law School. To the extent there was any populism, it would have been canceled out by the fact that Dr. Rogers, the Commonwealth's expert, also had a longer time affiliation with the Harvard Medical School. So Harvard was thrown around by both experts, and I definitely don't think that it was used in a manner to sort of bring that up, but just to show that Dr. Rosmarin lacked credibility because he had claimed to have gone to Harvard Law School when in fact he didn't know anything about law. Justice Botsford, I believe.
For those of us who didn't go to the, I don't mean to.
Pardon me?
I don't mean to be frivolous in this case, but for those of us who didn't go to Harvard Law School, it may be that you can go to Harvard Law School and not know anything about the law. Right?
I agree with that. That's not my question. My question is...
I'd agree with it, but...
It's an argument that the defendant makes, and I really haven't given it much thought at all, but here it is. The instruction, model instruction on you're permitted to infer the intentional use of a dangerous weapon is malice. And I think what the defendant is arguing is put aside whether it's mandatory or whatever. Assume you're permitted, not required. Nonetheless, is that substituting a permissible inference for the jury having to think about, maybe it's a good idea, but anyway, having to think about the more complex definitions of what malice is? They can just wipe that away and just say, well, gee, if we find... You know, if we find that he intentionally used a hammer, we don't have to worry about, you know, did he intend to kill? Did he, well, actually, it's an extreme atrocity cruelty. We don't have to worry about the second or third prongs of malice. We can just go there.
Well, I think it's clear from the instruction, which has been approved, the identical instruction.
No,
is
I
very
understand it's
similar.
been approved.
Right.
I'm not saying
I'm just saying that as a matter of precedent. But I see your point, but I believe that in the context of the closing as a whole, the issue really was the defendant's capacity to form the intent. That was the question.
To do whatever, to reach
Right,
for
to
the
do 1,
hammer,
2, 3.
to, yeah.
Right. Whereas the instruction went to whether or not he actually had the intent. The Commonwealth had to prove not only that he had the capacity, but that at the time he inflicted the blows, he actually did have malice. And I think the instruction made clear to the jury that when they were determining whether or not he acted with malice, they were permitted but not required to use as some evidence of malice the fact that the use of a dangerous weapon.
That's not what it says. It says you are permitted to infer that a person who does this is acting with malice. It's not just some evidence. It is malice.
Right. It's saying they could find malice based solely on that. It did not tell them this is the only factor that you can consider when determining whether or not he acted with malice. And I think that in this case especially, assuming that the jury found that he had the capacity, the number of blows, the viciousness of the attack, the jury would have to conclude not just because he used a dangerous weapon, but the way he used it, the number of times, the circumstances, the fact that the victim was in his 60s and on an oxygen tank and infirm, that they would have had to find malice even without the instruction having been given. I think it's clearly permissive, and it does not, like the Stilwell and the Richards cases,
No, it's not, I'm not really talking about whether it's permissive or mandatory. I
Right.
agree with you. It's really about just, maybe it's a good idea, but anyway, it's just, it's an easy substitution for having to think about the second and third prongs, whether
Yes,
they've
it
been
is.
met.
Yes.
And I'm not sure that's
I agree
what-
with that, but the law provides for it. It has said it for a very long time. It said it has, as far as I'm aware, the instruction model, jury instruction number 61, has never been criticized by this court. The longest string cite of my career was 12 cases in this case, for all the cases that have upheld the instruction. So, yes, I see your point, but, and if the court wants to change the law, because it may be that it has a disproportionate impact on the jury. It may be that the jury would say, well, gee, he used a dangerous weapon. You know, that's the easy part. And that, of course, is for this court to decide. But it has never so held. And I think it should not so hold in this case, given the other evidence of the severity and the nature of the attack. I see my time is short. Unless the members of the court have no further questions, I'm happy to rest on my brief and ask the court to affirm the conviction and not to grant relief pursuant to 278-33E.
Thank you, Mr. Steinfeld.